Good morning, Sarah.
Good morning, Jackie. How are you today?
I'm very well, thank you, and I'm glad to be back again.
Yes, it's been a while, but
it has, isn't it?
We're back and the sun is shining.
Exactly, all is good. So today, everyone, welcome. We'd like to have a bit of a chat really about the new divorce law. There's been a lot of talk about this. It's still relatively new. The law in relation to divorce and also dissolution of civil partnerships was actually amended quite some time ago, but came into force on the 6th of April this year. So it's taken a little while to come through all of the channels in terms of Parliament, and obviously Brexit and a few other things held it up, but it's here now. It's been with us for just over a month, and not only lawyers and the legal community are very excited about this, but in general, I think the feedback we're getting and we were receiving leading up to the changes is that the public also wanted this to happen, that it was something that everybody was crying out for, because the fundamental change with the amendments as of 6th of April this year is that we're looking at a divorce situation now which is not based upon behaviour and fault. So it's a no-fault divorce. So the only reason that anybody has to give to be able to divorce is that of irretrievable breakdown only. So it's not based on separation, adultery, negative allegations as to behaviour. So it's really steering away from all that conflict as much as possible, which definitely as resolution trained family lawyers, we're really supportive of that move, because it means that it's a positive for everyone. We're moving away from a language which is about really criticising one another and can be so unhelpful in terms of resolving other issues as well. So we're quite excited about this, aren't we, really?
Yes, yeah, I think it's nice because some of the most difficult cases were when people came in and said, we've just grown apart, but actually then their only options were either to come up with specific examples as to how the other person's been unreasonable, but actually they may still have children who they're going to parent together, and they've got that relationship, and making those allegations damages that relationship, and it's the children that suffer the most. So it's nice that those people now don't have to make the allegations or wait 2 years to have the divorce. They can now divorce in a good way, or as well as possible, but it starts from a conciliatory position as opposed to you're the one to blame for this, and that's the reason why we're separating.
Yeah, absolutely. And it's much more in line with how we've always wanted to advise clients that things should be fair, things should be conciliatory, but at the same time, obviously, we're here to give robust advice as well. But if things can be dealt with as smoothly as possible on the divorce side, then let's concentrate on the other issues, which may be more contentious.
Yes,
and have a focus on those things.
I think it's helpful in terms of, we talk about the amicable divorces because there has always been those, but those more acrimonious divorces, because not everyone separating will be amicable, but actually all you do by asserting blame is to increase the animosity between the people. And make the possibility of agreeing arrangements for the children and the finances all the more difficult. So it helps both ends of the spectrum to take that blame out of the divorce process, and to just say, right, we are irretrievably broken down, let's focus on the other issues.
Yeah, absolutely. Yeah, it's a much calmer foundation for everything, isn't it? A better starting point. And what we've got in terms of the actual process and procedure, which is quite new also, is that not just sole applications can be made by one party or one spouse, that it can also be made jointly as well, which is really quite innovative. I think if we've been asked as family lawyers previously, could a divorce be initiated by both parties, we would say, well, that's not quite right. No, it can't be. How can that work? And I have had clients ask me that previously, many years ago, especially in situations where they have just drifted apart and they haven't wanted to basically create some sort of negative background to the breakup. So we've got that now in terms of joint or sole applications. We've also got a change in the language, which may be semantics, but it's also really trying to move away from the combative nature of divorce as it used to be. So rather than a petition, we've got an application, because you are applying, and you're applying online as well. So online divorce came in previously, but it's really now waking up, and this is the way that it's going. So there will be online issuing of the application, but online service as well, in terms of emails and paper really going out the window. There'll be very rare circumstances in which you have a paper divorce. The other changes in the language are that of Decree Nyside, which was the interim order. That's now a conditional order. And then rather than having a decree absolute at the end of the divorce to say that it's absolutely over, it's a final order. So it's really matching in many respects, perhaps civil law, and more of a language which is less about arguing as a separating couple. So it's meant to have an influence on the way that the proceedings are conducted as well. So also what we're going to see, you were mentioning, Sarah, about taking out the conflict and the stress, and really that whole generating stress about the divorce as opposed to the other issues. Hopefully also it will reduce the costs in terms of the divorce, because a lot of the time people get absolutely fixated for good or for bad with issues about the breakup of the marriage, as awful as it may be and as sad as it may be, and that can generate its own cost situation, which just absolutely explodes if you're not careful. And that really isn't the side which perhaps needs to be focused on, when in fact people's resources should be better applied in terms of looking at the children's issues and the finances. What appears to be the case is that the court's really not going to be interested in costs when it comes to divorce. There would have to be a fundamental technical reason as to why perhaps even there's going to be defended, or as is now referred to, disputed proceedings.
But of course the reasons for now disputing a divorce are, you can't defend it in the way that you would defend the allegations of unreasonable behaviour, because one person is saying the marriage is irretrievably broken down, and as I often say to clients, the fact you're here and you're issuing divorce proceedings means the marriage is irretrievably broken down. So now the defence to the divorce will be, again, procedural issues, that the court doesn't have jurisdiction, for example, as opposed to, no, I think this marriage should carry on.
That's right. So it's really limiting that time, or that window of opportunity to raise an issue about anything, and saying, look, unless it's something really procedurally, technically, which needs to be addressed by the court, with the greatest respect, it's about dealing with this in a respectful way for those involved, and moving forward and concentrating on the bigger issues. So, and we've got the procedure. I mean, that's why we're here as family lawyers, to advise you about the procedure in terms of the actual timings of everything. The timings are slightly different. You file online. 28 days thereafter, the court will actually serve on behalf of the parties if it's a joint application. There's lots of other sort of bits to it in terms of whether you've got a lawyer acting, whether it's a sole application. And then it's pretty much, in terms of the actual procedure, it's pretty much the same, but there has to be an acknowledgement of the service of the application. And as long as really that service happens as it should, 20 weeks after the date of issue of the application, that's when both or one of the parties can apply for the conditional order, which is the decree Nyside that used to be. Now, that was always a fundamental stage within not only the divorce proceedings, but also how it impacts on financial issues and other matters. Because decree Nyside means that you've pretty much got 2/3 of the way through the divorce proceedings, and by that stage one would hope that there has been some advice taken by both parties as to other issues about finances, children, and also some sort of perhaps working draft document as to an agreement, an order concerning the finances. So really by then you're looking at something which you're hoping to be able to lodge with the court for the approval of the judge by consent. So it's absolutely fundamental not to, on the one hand, rush the process, but also to ensure that if the brakes do need to be put on, they're put on at the right point, so that these financial issues can be looked at and explored before moving on to the final stage, which would be the final order that was previously referred to as decree absolute. So that's the fundamental bit that we as lawyers are now concerned about. After the initial elation of, we've got the new divorce law, it's amazing, what we may be seeing, and what we may see more of, is that for some separating couples who quite rightly believe that the actual divorce itself is relatively simple, and may feel that there's not much in dispute that needs to be discussed, they may be overlooking fundamentals which they need advice on.
Yes, and I think those most at risk are those who think that they have reached an agreement and don't think that they need to formalise that in any kind of court document. Or those where there are pensions and they haven't properly, and they've said I'll take the house rather than pension, but not properly considered the ramifications of that. And there is a risk, I think, that the whole process may actually take a lot longer, because you will either be having people not taking advice at all, and then they're not going to necessarily get what they're entitled to, but equally you might have people who don't take advice until the point of the conditional order, and then you have to start the whole negotiation process, whereas actually the right time to get advice, even if they decide to then issue the divorce proceedings themselves, is at the start of the matter, so that the two processes can run alongside each other. Because I don't know about you, but I often find that people assume that the divorce encompasses everything, and that by doing the divorce, that everything else will automatically be resolved in terms of finances and children. But they're very much processes that run side by side, as opposed to one process as a whole.
Yes, indeed. I don't think actually anyone could possibly take advice too soon in terms of that. It may be only initial advice, and it may be advice that obviously needs to be reviewed subsequently. So perhaps then, once having taken the advice, get the divorce issued, and then come back a little bit further down the line, but not to leave it too late, because it's really important that it doesn't become a runaway train, and that people think or underestimate the whole importance of the situation, that actually there may well be issues that you do need advice on. So legal advice from us, but also technical financial issues, be it from an independent financial advisor, actuaries on pensions, all of that information piecing together can take time. And so really the best thing is to front load it, take the advice, find out the areas that you do need specific further advice on, maybe reporting on, and actually get that front loaded whilst the divorce is happening concurrently, so that you've prepared as much as possible, really ideally before you get to the conditional order stage. And it's about, it's protecting people, isn't it? It's protecting our clients and making sure that they're not losing out on something which they may well have been entitled to. May transpire that in fact they don't wish to pursue that claim, but without knowing what's available and ensuring that it is still available in terms of the law, then they're put at a disadvantage straight away. Yes,
I think it's a case of recognizing that you don't know what you don't know, if that makes sense. So that although it's been widely publicized, this divorce process is simpler, that actually, as you say, you need to come in preferable to come in at that first instance to find out what you need to know and what information you need to gather to then make a decision about how you move forwards.
Yes, that's right. And also it's a time factor. I remember several years ago a client coming to me who not only did she not feel she had the legal know-how to deal with her divorce, but it was also more of a case of she struggled to try to actually deal with the divorce in person as the petitioner, as it was back then, so she could be applicant now, and it was just too onerous, even with a straightforward divorce, as it may be, and as it is now, and it's meant to be under the new procedure. It's still going to be time consuming, quite exhausting for you when you're going through that whole emotional turmoil, and having to deal with all other things in life as well. So I mean that's the other reason that we're here, is to obviously to give the legal technical knowledge, because we're the experts in that area, but also because we take the strain, we take the burden, we're here to do that work for you. So even with this online procedure, and we know even from our experience of dealing with the online procedures, they're still time consuming, and there's still elements to it which you really need to slow down and think about. So it's very easy to really underestimate the importance of us getting involved and dealing with that. And I think that would be our concern. So after the initial excitement about it, which long may that live. But it's the whole thing about actually, are some people now really not appreciating that there are other elements that need to be looked at still. None of that has changed actually in terms of the children and the finances.
No.
That's exactly the same.
Yes, yeah, but I suppose that previously, when people felt they needed more advice in relation to the divorce process, they would be alerted to that fact when they initially come in to meet us, and we give them the advice about the whole package. Whereas now there's that risk that either they start on the divorce process and get so far along before thinking, oh, I haven't thought about this, about the financial issues or the children issues, or they just merrily say, well, there aren't any assets, not appreciating that they still should get a financial order. You get the decree absolute and the ramifications of that. So going forwards from this podcast, the purpose of the series will be to look at the specific points that actually these are issues you need to be considering and coming to us for advice about.
Yeah, absolutely. We can expand upon that, can't we?
Yes, yeah. So I think that covers the kind of overview of the new divorce process, and we'll be back soon to talk about sort of the potential pitfalls of specific areas.
Yes, yeah. Look forward to that as well.
Yes, it was lovely to see you. And
you, Sarah, and you, and everyone have a brilliant day. You know where we are, and we'll see you again soon.
Thank you very much.
Okay. Take care. Bye-bye.
Bye.